today we're really excited to present Sheri Thomas from Santa Cruz County. We're going to go over Prop 19 information, and then she'll also open it up to go over like any kind of Q&A that you have at the end. Other than that, we'll take the floor. Great, thank you.
Good afternoon, everyone. Thanks so much for having me back here. How many of you have heard my presentation before, Prop 19? Few of you, but not many. Okay, that's great. Prop 19 has actually been in effect, can you believe it, for 4 years now? We are still figuring parts of it out. I currently have one function with the State Board of Equalization. It's been there since February. They told me it's legal, and they'll have an opinion sometime this summer. And just this morning, I had one of my staff email me another question where we don't know what to do. But fortunately, 90% of the stuff we have. So most of the common situations that you're going to encounter, we have it nailed, we're working them, and I can tell you all about those. If you come up with one of those weird scenarios, I'm probably going to defer on that. But Prop 19 made simple. Sort of an oxymoron, so I'll do my best. I do have a short presentation. I left a long time for questions. But in addition to transferring your tax base, taking your tax base with you, I do want to cover a little bit about the Prop 19 portion of inheriting properties. Okay, and I don't know if you come across some of your clients who are inheriting, how can they keep their local property tax base? And there is a new wrinkle that we just discovered in December. The State Board of Equalization came out with an opinion that taxpayers can inherit their parents' tax base if they qualify, and then take that tax base with them to replacement property. So that's a big thing that we didn't think was possible. They came out in December. That one we'll talk about a little, but it's really, really tricky. So if you have that situation, your best bet is to contact our office. Pretty much anyone in my office can talk to you about Prop 19 nowadays. It just is taken over our life. So Prop 19 made simple. On the right-hand side of the screen here, if you have your camera out and you want to take a picture of that QR code, that's the link to the last year's 2024 Assessor report. It's about 24 pages long. It has just tons of information and stats about the assessor's office, assessed values, Prop 13 values, and anything else you can think of. And we will be doing one of those every year. So first, a disclaimer. I'm here to talk in general about Prop 19. If I make a mistake or a misstatement, the tax code, the law actually controls. So you can't take what I say and say, well, Sheri said I can do this. Just a disclaimer we have to add. First, in order to understand Prop 19, you have to understand Prop 13. And I sort of assume that everyone in the industry knows about Prop 13, but I'm finding that that's not entirely true, so I'm going to cover it really fast. Voters approved Prop 13 in 1978 in response to dramatically rising interest rates, property tax values. Does anyone know how the property tax worked before Prop 13? No? Properties were assessed at their market value every single year. And the taxes were a set percentage of the market value. Right? So as in California, as the market value rose, seniors, families, they were hit with these huge tax bills. They were house rich, but house poor. So Prop 13 was passed. So what Prop 13 did is it took it from that market system to an event-driven system. So now your property tax base is set when you acquire a property, whether it's by purchase, gift, fractional interest, any way you acquire a property, inheritance, or if you complete new construction. Those are the two triggers that are going to trigger an assessment. We value it based on that point in time, and that becomes your base year value. After that, your annual taxes are just that base year value plus annual indexing that occurs every year. And the indexing is the CPI index, but they limited it to 2%. So your assessed value is not going to go up more than 2% per year unless you have another triggering event. So what this means is that people who've owned their properties for a really long time have a really low tax rate. Right? My mom owns a property in South Bell. She's owned it since 1972. They bought it for $30,000. The assessed value is probably about $110,000, and it could be worth $1 million. But they're paying taxes on that really low value. That's why taking your base year with you is so important. All right, it's a huge savings for families, for individuals, anyone owning a home, and it's not just a one-time thing. It carries on for as long as they own that property. So that's why we want Prop 19. So the official name is the Home Protection for Seniors, Severely Disabled Families, and Victims of Wildfire or Natural Disaster. This is really will all become very easily there. It was approved by voters in November of 2020, and it has two distinct components. The first component is the parent-child exclusion. It actually reduced the benefits in this area, and that's not a good thing, but it's important to know what the requirements are now. And then the base year value, it expanded the benefits. Okay? They have two different effective dates. This picture of my dog at the beach, that's to remind me to be enthusiastic about the upcoming. Because it is a good thing. But in my office, we are just overwhelmed. Our world has changed and everything's Prop 19 these days. I did have to add 3 new staff members in order to deal with the workload, right? So in 2021, we had 21 staff members. It took me until 2023 to get one person to oversee the Prop 19. And then just last year, we got 2 new appraisals. And it's not just the base year value transfers, although that does add to our workload. The biggest increase in our workload is because of the changes that we made to parent-child exclusion. When we'll get there. So I am excited about Prop 19. So who could use a base year value transfer? Obviously seniors. And fortunately, they define seniors as someone 55 and older. That's great. The other people is permanently and severely disabled. There are very complex requirements for that. So if you're interested, there's the tax code. It does require a physician to certify and do a form as well. If the person is 55 years or older, just use the base year value transfer for seniors. It's just way easier. But if you're under 55 and you are permanently or severely disabled, this will allow you to do that as well. Victims of wildfire or natural disaster happening every year now. So it has to be a government declared disaster. The timing starts when the property is sold. So you do have to sell under this provision. You do have to sell your original property in this damaged state. You sell the land if your house burned down. We actually had someone transfer in from Butte County from the campfire in Paradise. I think that was in 2018. But they had owned their land all this time. They bought a replacement property, finally realized that they just are never going to rebuild. And so they sold their land and they qualified and were able to transfer their base from Butte County into Santa Cruz County. For those victims maybe of the CZU fire, there are other benefits that are available. And if the CZU victims are staying in Santa Cruz County, one of those other benefits is better for them. And most of them have been doing that. But if they want to go outside Santa Cruz County, they can use Prop 19. And they do, if they're going outside Santa Cruz County, they do have to sell their original lot. If they're staying in Santa Cruz County and they're using the other tax code to transfer their base, they don't have to sell their lot. So, some things there. Santa Cruz County on the bottom here. So far, we've received 402 applications to transfer the base year value. 2 were for the disabled and 2 were for wildfire. So the rest of the time, I'm going to talk about seniors. The rules are the same. It's just what class of people qualifies. Okay, so just in general, what was the intent of the law? It was to make it easier for seniors to move, maybe find a house that fits them better, or move to be closer to family as they're aging, whatever the reason is designed to help them transfer their base or buy a new property and keep their low property taxes. Some of the benefits that didn't exist before is you can take that anywhere in California. Before, it had to be in the same county. There was like 13 counties and took them from other counties, but no one wanted there. Now you can go anywhere in the state. You can buy up. Your replacement property can cost more than what you're selling. Again, before that was not allowed. If you bought up, you said no, you didn't get it. So if you do buy up though, the difference in value is going to be added to the value that you brought over. Right? You can't sell $1 million home and buy a $4 million home and expect to have the same exact taxes. Right? That was a real question. So that extra $3 million does get added to that. So there's still a savings, but because they jumped up in value considerably, it wasn't as much as they thought. You get to do it more times. Before, we got one shot under Prop 60. Now, each person, each individual gets 3. They can transfer it 3 times. And when you are a married couple and you are transferring your base, only one person is a claimant. That means that if you're a married couple and you have 2 people, you get a total of 6 times. I'm not sure that people are going to move 6 times as a senior, but it's possible. Another benefit, which didn't exist before, is the property that you buy or sell can contain an ADU or JADU. You all know what those mean, right? Okay. And again, before, under Prop 60, if it contained any extra living unit, even an ADU, we had to carve that out. And that section got assessed at market value, and the rest was had your base year value transferred.
So question about that real quick. Units then? Can they do units or no? Like this duplex, triplex, fourplex?
No, not multiple units.
Okay.
Okay, so you can do it to a duplex, but we have to carve out. There's going to be a portion of it. The non-owner occupied unit is going to be assessed at market, and then you carry your tax base to the unit that you live in.
Got
it. Okay. Multiple owners can benefit. This is a big one. I get this one a lot, so hopefully you all will share this information. So I have, for instance, parents want to move close to the kids and help their kids get into housing, so they're going to buy a property together. You know, maybe it has a house of ADU. Maybe it's just one house that they're all going to live in. All 3 or 4 of them are on title. All of them get to benefit from the parent, one of the parents, one claimant, taking their base year value from their old property to the one. Okay. What are the qualifications? You have to be for the seniors. You have to be 55 years or older when the original property is sold. So there's a little squishy room here because one of the other requirements is timing. You have to buy or and sell within 2 years of each other, and it can occur in either order. So you can actually buy a replacement residence before you're 55, and then wait till you're 55 to sell. So that would work. But it has to be the 2 years. You don't have to meet the 2-year requirement. It has to be your primary residence. Okay, vacation homes don't count. We've had ones where people say, well, my kids live there, but I have a room in the home and I can go there anytime I want and I have some of my stuff there, but I sort of live somewhere else. But I still have my room there and it's mine. It doesn't count. It has to be your primary residence. And you can only have one primary residence at a time. And the state does track this through the homeowner's exemption. So whenever people file a homeowner's exemption, which is where you get a tax benefit, but also declare that you're living there as your primary residence, you have to give your social security number, and that's reported to the state, and they track that. And if they find any duplicates, they'll contact the counties and say, hey, you guys gotta figure out what of these have to come on. Timing, we covered that. It can be done within 2 years. There are some times when the timing matters. And so we'll cover that on the next slide. But in general, you buy, you sell, either order within 2 years. And that 2 years is absolute. There is no consideration for disasters, for COVID, anything. In order to get an exemption, the legislature has to approve it and put it in the tax code. And that happens for some of the larger fires that are happening. One of the other fire bedrooms you have to replace it within 5 years. And they do add to the tax code that say, including for Santa Cruz, you have the 7 years. The CZU fire that happened in 2020, it's actually anything that happened in 2020 because of COVID, it gets extended for 2 years. So that's a different code, but it has to actually be the tax code. So if you're pushing the limit on the 2 years there, you have to be very, very careful. The other thing is you have to file a form with their office. We don't know that you want to transfer your base rate value. Sometimes on the preliminary ownership report, there's some little check boxes, but that's not the same as the application. You also can't submit the application with escrow to the recorder's office. You have to submit it directly. It's a separate process. It's an easy form. You have to send the form to us. Okay? If you forget, you do have up to 3 years to do so. I don't know how anyone forgets because you're paying the higher taxes on in the big tax, right? If it goes over 3 years, pretty sure this is true. If it's over 3 years, you could still apply, but it's not going to be retroactive. So it's going to be from the year you apply. Okay. Any questions there so far? Yeah. So when timing matters. This one, I'm gonna have to look at my notes on this one. If you're buying up, it is actually more beneficial to sell your original property first. Because there's this thing in the real estate market called, sorry, I'm getting over my brain, so this gave me the time value adjustment, right? So over time, generally the market goes up, okay? So that's built into the law that assumes that the markets are going to go up over time. And so if you sell your original property and then buy your replacement property within that first year, they're going to give you a 5% bonus on the value of your original property. I have some math later to walk you through this because they're hard to articulate. And the important thing is that 1 year after starts the following day. So if you have a client who's buying up, work it with escrow if you can, that the sale closes first, and the next day it goes on the buying. Okay. And then if it happens within the second year, you get a 10% bonus. Okay. In our county, in Santa Cruz County, because we had this issue came up, and our legal counsel told us to do it. So this is how we will do it. I can't guarantee that another county will do it. We will give you the 5% bonus if the sale is recorded second, even if they're on the same day. Okay. You can't guarantee that other counties will do that and they will do the next day. But our legal counsel is interpreted that way, so that's what we do. If you buy first, you're gonna have a higher tax base until you qualify to take your base rate value transfer. When you qualify, if you buy first, if you buy first, when do you qualify? When you sell. Okay, because it requires both a buy and sell. You don't qualify until you completed both things. So you will be responsible for the full value, the assessment on the full value, until such time as you qualify. Then we'll work that event and bring your taxes back down. That's all adjusted through the supplemental events, which is a whole nother discussion. that we can talk about later. And then transferring your base of an inherited property. Again, it's possible. Now we know that that's possible, but it does take some, the timing matters. So you need to contact our office. All right, so this is the math. Sorry, there's just no way around it. Yeah.
I'm not following the 5% the first year and then the 10% that you're going to do.
Right, it's right here.
All right.
Yeah, so in the blue box, the value comparison. We compare the value of the original property with the value of the replacement property. If the replacement property is higher, we have to add that difference. But if you buy the replacement property second, that's the second step, we're going to give you a bonus of that 5 or 10%, depending on whether it's in the first year or the second year. So probably the easiest thing is just to go through the example. The original home sold for $400,000. It's not in this county. And had an assessed value of $100,000. The replacement home was purchased in the first year for a sale of $600,000. So they sold for $400,000. They bought for $600,000. That difference of $200,000 is what's is added into what they're carrying over. They're carrying over that $100,000, right? So now their new assessed value is $300,000. But if they buy in that first year, they get that 5% bump up. So we take that $400,000 times 105%, it's $420,000. So what we're comparing now is $600,000 to $420,000, and we only take that $180,000 difference. Okay, and so their new assessed value is $280,000 instead of $300,000.
So your basis is better in the first year. Is that what you're saying?
No.
It's the reverse. It's in the second year your basis.
This only applies if you're buying up. If you're buying a house worth more. Okay. If you're buying down, you don't need to worry about this. Or if you're buying for the same amount. But if you're buying up, buying up, you can help them save more money on their taxes by having this discussion with them. Sometimes it just won't work. You know, their personal situation requires them to do it in whatever order. But if there is an option, you can save them. And again, it's not just a one-time savings. It's that $20,000 plus $200. But it's $200 every single year, right? Plus the annual investment. So even small amounts matter. And again, these aren't realistic values for our county. So you multiply this, times 3 to get your realistic values. Okay. Any other questions on this one? No? Okay. So as I said, you have to apply. Right? We're a government entity. We like paperwork. Right? There's just no way around it. Plus, it's required by the state. So we can't do it unless you file the paperwork. It's really easy. You file the claim form in the county in which your replacement home is located. If you sold in Santa Clara County and you moved to Santa Cruz County, you don't have to do anything in Santa Clara County. You have to do it here. Once you qualify, means that you've done both sides of the transactions, you bought and sold, and you moved in. There's a Prop 19 claim form on our website. Call us, we'll help you get there. In addition to that, they will need to provide proof of age, like a driver's license, copy of the driver's license, copy of passport, birth certificate. We don't really care as long as it documents their age. And file a homeowner's exemption claim form. Okay, that is going to give you the biggest benefit.
Can I ask a question?
Yeah.
So the filing deadline is 3 years, but your bonus system is year 1 and year 2. If I have a client that sold a house, they're renting until they decide to find their permanent replacement, and let's say they bought it in the 3rd year, do they miss the bonuses of the 5 and 10%?
They don't qualify.
They don't.
No. So there's the requirements of the program.
So they're over 55. Obviously.
Right, but it's 2 years. How do you get a bonus? They have a lot of sell within 2 years. This is just claiming the benefit.
I see. Okay.
Yeah.
So they, but if they do it in the second year, they get the 10%?
Yes, if they buy up,
Yeah.
they'll get the 10%.
Okay. Okay.
Because the market generally is going to be higher. You know, this was a huge problem with for the CGU fire victims, right? Because what happens is we had to value their property as of the date of the fire. And then by the time they got around to getting their insurance settlement and buy replacement property, it was 2021 at the earliest. And what happened? One, Prop 19 took effect, so we're getting all the buyers from Santa Clara County coming over here, and they just sold their 50-year-old ranch home for $3 million. They offered way over. So the values just went all up. And it really priced a lot of the CZ buyer victims out of the market then. Yeah.
Are all the counties the same across in California as far as like if you went to Santa Clara Reversal, like you said a minute ago, you would have to file in their area and not in Santa Cruz?
Right, you file where your replacement home is located.
Okay. All
And
right.
this is a state law, right?
Okay.
So it's statewide.
And everybody's got the same rules, right? Okay.
So there's
Yeah.
58 assessors throughout 50 counties, so 58 assessors throughout the state. And we are elected, so we have a lot of incentive to give benefits to the taxpayers, right? So there's an overseeing entity called the State Board of Equalization. And they interpret the laws, they give us rules and guidelines so that all of the counties are enforcing the law the same way.
So it's regulated.
It's regulated,
Got it.
right? There's still small differences, like I said earlier. My county council interpreted after to be, it's reported after, but even the same day. Other counties might include that it has to be the next day. Right? So there's minor differences. But overall, it's going to be the same no matter what county.
Got it.
Oh, I got through that first. Do you want to do questions now, or do you want to hear about parent-child first? Parent-child. Okay. So, Proposition 19. So again, this Prop 19 really reduced the benefits for inheritance between parents and children. So in California, properties are subject to reassessment upon change of ownership. Whether it was up to the board by gift, purchase, hi again. So when a person passes away, that property is subject to reassessment. Under Prop 58, there's one exclusion that's universal that hasn't changed, and that's spousal. So if you're a married couple and your wife's still alive, your husband's still alive, we don't reappraise it in that situation. There's no paperwork required for that. I mean, technically, you are required to file a death, notify us of a death, so that we can correct title. Okay? And that's supposed to be within 180 days of a death. And there's a special form for that. There's a form for that. And technically, there's fines and penalties if you don't do that form. I'm on camera, so I can't say anything about that. But we haven't implemented that yet. So, but parents and child, under Prop 58, children could inherit their parents' primary residence no matter what the value was. Okay? They could just inherit it. They didn't have to live there, they didn't have to do anything, they just got the house. They could turn it into a rental, they could sell it, they could do whatever they want. They got that low tax base. They also got to inherit the tax base of up to $1 million of assessed value of other property. That's how it was before. And I'm talking about the assessed value. So it could be a shopping center that they've owned for decades that has a really low value. It could be rental properties. So we've had estates where they're inheriting 15, 16 properties. And the market value of those now is just astronomical, but the law says the assessed value. And that's per parent, right? So you can inherit $1 million from one parent and another $1 million from that other parent. And as long as the children file the paperwork with our office, we didn't do anything. We didn't look at the values. We just, this parent-child, we're done. We'll just update ownership, and that's all we had to do. Prop 19 changed that. So now, Prop 19 says that except for spousal, whenever there's a death, we have to establish a market value for that property, no matter what. All right, so that's why our workload has increased dramatically. The child can apply for a parent-child exclusion if it was the parent's primary residence only. Everything else, no, it's gone. It's going to get reassessed. But if it was the parent's primary residence and the child, one of the heirs, one of more of the children, sorry, not just the heirs, one or more of the children, moves into the residence within 1 year and files for a homeowner's exemption, then they can receive the exemption amount, which is different than just receiving the base year value. Okay. It's that moving in to the residence with 1 year that's really become a problem. There are some situations, there's examples where the property is locked up in probate and whoever is in charge is not letting anyone move into that property. If no one moves in within 1 year, it's gone. You can't do it. Okay. So fortunately, they're working on legislation to fix that part of it. Okay. But that is a big sticking point. Yeah.
Is it a separate form, or what is it totally different
It's
form?
another form.
Okay.
So I think we have at least 100 forms. And again, remember that I talked about that overseeing entity, the State Board of Equalization. They give us the form and say you have to use this form. You can't change the form other than letting your letterhead, and it has to be an original signature, a wet signature. So we're working on. We just got legislation passed last fall to allow for digital signatures. It required a bill, right? So, and now there's still confusion about what does that mean. So we're still rolling it out, but yeah, it's a required form. Is there something here?
Parent child, the one parent dies, the other parent is living there, but doesn't affect house to house to bring the children. And the parent does move out, but the surviving spouse doesn't move out.
Does the surviving spouse, is there a life estate?
Yes.
Yes. Did you email a question about that? We just had that discussion come up. That's what we did. Yeah, so the question is, a spouse dies, the property is in a trust, the executor and beneficiary of the trust is a child, but the surviving spouse, who does not have any ownership interest in it now, has a life estate, meaning that they're entitled to live there during their life. So the 1 year time period, we had to research this. The 1 year time period doesn't start until they pass away or they move out and cancel that life estate. So in that situation, it's when the life estate ends. Okay. You first?
Okay, how long does the child have to stay in the home before they sell and use their exemption?
If the child moves out, we remove the exemption.
If the child moves into the parent's home
Mhm.
and they have the exemption,
Mhm.
and then they want to use the exemption to buy another home and move out.
So they want to take their base year value with them. That's where it gets tricky, and we'd have to we'd have to go through this specific situation. Sorry. They have to live in the property until I actually forget this. So the issue is once they move, that exemption goes away. And so the Board of Equalization did this really tricky phrasing on how to make that happen. But it does have to happen. It has to happen right away, immediately. And I think it has to be, actually, I don't want to make them say it wrong thing. Yeah.
Maybe a stupid question, but is the parent-child exclusion only upon death, or can I do this 3 times to my 3 kids while I'm living?
Well, it has to be your primary residence.
Yeah.
You can gift it to your children. and they have to move in.
Yeah.
So then you're gonna move somewhere else and establish that and give it to them.
Yeah.
Yes, but you don't get to, if you give your base year value to your child, you don't get to transfer it to a different property.
Got it.
So that's my question. That was gonna be my question, but I have kind of literally did that. They did the exact things, and they've been told otherwise. They've been told they can use both.
That's very clear. You cannot do both. That's
I
why
showed them that it's very clear on your site,
yeah.
and then they showed me a site at the state level that said otherwise. So I was very confused. I was like, I mean, this is what Santa Cruz County Assessors said.
Yeah, well, send me an email.
Yeah.
We'll work through.
They should have started the conversation with you guys, apparently.
Right.
So basically double dipping, correct?
Yeah,
There's
there's
no
no
double down.
Yeah, right.
It's and that's why it's and that's a long-standing policy in property taxes. There's no double dipping. Okay, and that's why taking your base year value from an inherited property is so unusual, because that really is double dipping, but somehow they manage to finagle it around. It shouldn't be anyway.
So to be clear, I sell my house to my kid. My kid takes my tax basis. I can't go take my 55-year-old exemption and move it over to the new property. Okay.
But you can't sell it to your kids.
Yeah, you can. No, because so it's two different things. If you're so that's the other thing. To transfer your base year value, you have to sell, right, or buy. Okay, 100%. It has to be 100%. But for the parent-child exclusion, that can be by inheritance or gift.
Right, but not sale.
It can be sale. You can sell it to them, and they can. I mean, it's whatever you work out with your children. Oh, okay.
Inheritance, sale, or gift.
Or parent-child, yes. Yes.
With 140, would you tell people as far as what their intention is, what direction, what arm you use?
It's pretty clear on the website. Proposition 19, base year value after whatever. All right, the forms are pretty clear. If you, for instance, if there was a death in the family and you change that, you filed that death notice, change of ownership death notice with the assessor's office, and we see that there might be something that you want to do, our office will reach out to you and say, hey, do you want to do this? Here's the forms. But the problem is when you don't do it, so you don't tell us what's going on, we don't know, you could miss valuable time periods, right?
Yeah.
And so we can't advise you if we don't know about it.
What if the kid is 55 or over
Mm-hmm.
and they stay 2 years and then sell? Do they start their own base year off that base year? I mean, I know I'm splitting hairs in a way, but
So they inherit,
yeah.
okay.
So they get the base year from their parents.
Mm-hmm.
They're 55 and they stayed 2 years. I think it's 2 years, right?
Yeah, there's actually not a defined
Okay.
thing how long they
And then they move on.
Yeah, that's the scenario that I'm talking about.
Okay.
Okay, that scenario is where you have to call our office because the timing matters.
Okay.
And I don't have it memorized yet because it just happened in December.
Okay.
Go ahead.
So we are always talking about child exclusion, but there are some homeowners, they don't have like child, but they have sisters or brothers. Is that going same with them? Like when senior dies, her property doesn't go with sister, or
There's no exclusion for other family members. The difference is grandparent, grandchildren. Okay, there is a carve out for a transfer between grandparent and grandchildren if the intervening child is deceased. So if the parent still, if the intervening parent is still alive, yes. Go ahead.
So in this instance, it says the child. So what if, in the trust, there are two children, and they each inherit, but only one of them moves in? They still get the full exemption?
Yes, initially, Yeah, so if they both become owners of the property and 2 or 5 children, however many, as long as one qualifying heir lives in the property and files the homeowner's exemption, the property will receive the exemption. If that one qualifying child moves out and they want to let someone else move in, they can still do that, but they have to file the appropriate paperwork that then can keep it. If that one child wants to take 100% ownership and buy out their siblings, that portion is going to be reassessed. So if there's 2 children, one buys out the brother, it's going to, if they had 50%, it's going to be a 50% reassessment.
So it's only the 50%.
Well, it's however, it's permitted to however many children there are. If there's 5 children, they own 20%. You buy out 3 of them, but not the other ones, that portion is going to be reassessed.
So instead of buying them out, there could be a refinance cash out to pay out the child or the other heir and still keep the tax base.
That is true. So the way to do this, if there's multiple children and it's in a trust,
The trust has to take out the loan.
the trust has to take out the loan.
Yeah.
And none of the heirs can contribute money to that loan.
Yeah.
So it has to be a third party loan for the trust that then he uses to pay off the other children. And then upon disbursement, the one child is the only benefit. That way. So talk to a mortgage company about that. I don't know about those things.
So it has to be a hard money loan that basically lends the money to the trust, because regular conventional won't lend to the trust. So you get a hard money loan, do that, and then they buy it from the trust.
And then refinance. Convention.
They buy from the
Yeah.
trust and
The beneficiary.
the sibling owns the property with the exact Prop 19 tax base.
I love money.
Right? No?
Or needs to. So they would qualify for the exemption. So this is, let me get to the second part of this, because there's another little wrinkle in here, sort of a big wrinkle. Before, under Prop 58, again, the parents, no matter what the value of the house was, if it was the parents' primary residence, the kids got it. It could be a $3 million house, $10 million house. They got it and they inherited the tax base. Okay. Under Prop 19, only $1 million is excluded. All right, so there's a limit to the exclusion. The $1 million does adjust every 2 years. In February, it's super annoying. It adjusts that way, but it does. So let's just go this and we'll go back there. So these on the bottom of this one, Prop 19 allowance. This is what it is for the 3 years. So now, as of February 16th, 2025, it's $1,044,586 is the exclusion amount. So for talking purposes, I'm just going to use $1 million, but it's actually a little bit different. So you have to know a couple different things if you want to figure out what the child's tax base is going to be. So they qualify for the parent-child exclusion. They're going to inherit the tax base. What is it going to be in reality? So you need to know what the parents' Prop 13 value was. You need to know the current market value of that property and which allowance they need to take. And then here's a little math. This is a cheat sheet. You guys ever remember in school and you got the answer right, but the teacher still marked it wrong because you didn't do the math? Well, this is an example. So the answer is right, but according to the tax code, we didn't do the math right. This is the easy way. This is the easy value. So take the market value. What's the market value of the house? Example A, it's $1.9 million. It's a typical Santa Cruz home, right? The Prop 19 allowance, this happened 2 years ago, so the Prop 19 allowance was $1,022,600, and the difference is $877,400.
Does the assessor's office determine market value?
Yes. That's why we're doing it.
Not realtors.
Example B, the market value, it's in $700. The market value is only $900,000. So you take out the Prop 19 allowance, it's a negative number. This is the only time where when you have two values, the assessor's office picks the higher value. Every other time I pick the lower value. So we have to pick the higher value. So instead of inheriting that $250,000 property tax base, if the property is sold for 1.9 million or is worth 1.9 million, their tax base is $877,000. So they saved $1 million on assessed value. That's $10,000 a year. But it's not the same as just inheriting the tax base outright. Okay? And yes, the assessor's office is the one who has to determine the market value. And most of these are properties that haven't sold, right? They've been in the family for generations.
Yes.
We don't know what they're like. We don't know what the insides are like. We're having to make these. So we are working.
There is an appeal process, though, right?
There is an appeal process, but there's two appeal processes. There's an informal process with our office. We're working on a form. We're trying to get ahead of it to mail out a request for information before we value it. But we're trying to cross all these as fast as we can. So our appraisers go out there, they look at the file, they assume it's in average condition, and they do an analysis, unless they can obviously see in poor condition. We do the determine the market value. We send a notice and say, hey, this is the value that we are going to enroll on your property. You call us within 60 days, and we can work on that. Actually, if you call us within 30 days, we might be able to do an adjustment before the tax bill goes out. Okay, so if you have clients and they get these notices and they disagree with the value, you think the value is wrong, it's really important that you contact the assessor's office. Oftentimes there isn't a state appraisal. Right? Just send us the appraisal, because not only does it have their opinion of value, which we may or may not agree with, but it has information about the property, right, that we just don't have access to. Okay. Did you have a question?
So I have a couple questions.
Okay.
What do you guys, how do you do your appraisal when you don't know anything about the property? Do they do a drive-by? Do they just look at the square footage and the age and say 4 or how do you guys?
I mean, we know everything about the property, right? We have the files on the property. What we don't know is if there's, the other thing that we're having is a lot of unpermitted construction that we find.
Not at our
Not in
county.
this county. Right? So when that happens, once we discover it, we have to do escape assessments of up to 4 years and pick up that new construction. If they added a shed, we're not going to worry about shed, right? But they built a pool, 10 years ago, or they built a, 1,000-square-foot addition or ADU. We do have to assess for that. So yes, we do a drive-by. We look at Google Earth. We have our records. We do the best we can. That's what the law says. You have to do what you can based on the information you have.
Thank you for that answer. My second question is, all of this that you're talking about the parent-child inheriting it, and it has to be the parent's primary residence, if at any time during the ownership that the parent had it was a rental, does that eliminate it?
It has to be their primary residence when they pass away.
So it doesn't matter if it was a rental.
It was a rental 10 years ago, but it's been their primary residence for the past 5 years. No, it doesn't matter. Okay. Over here.
But let's say that someone forgets to file until like a year, 300 days later, and so they were valid for this, for that year, 300 days, whatever. Are they retroactive? Say, hey, 10 grand a year, I was charged extra because I hadn't filed with you guys. Do you guys retroactively? Is there some sort of payment back to them? Or in the case where they file and you guys are working to figure out the situation for 2 years, are they retroactively paid back if they're paying over?
All right. So the answer depends on which one you're talking about. Are you talking about the parent-child exclusions?
Maybe both, straightforward.
The answer is different.
Okay.
Okay. So for the parent-child exclusion, if the child moves into the property within 1 year, but they don't file the homeowner's exemption until 2 years later, the benefit is effective from that year that they filed a homeowner's exemption form. Okay, so there's a couple different things. One, you absolutely have to qualify based on moving in and establishing it. So this one, and then the other one is you have to file the homeowner's exemption. So it's not just one qualifying; you have to do multiple qualifying. So in that situation, in an inherited property, The benefit starts if you file it within that first year, it'll go back to the date of death. If you don't do it for a couple of years, it's only effective from that year forward. Okay. On the other one, the base year value transfer, as long as you file within 3 years, it's going to go back to the original event. Okay.
So in a standard, not parent account, just a standard transfer of face value, do both of the homes in the transaction need to have the homeowner's exemption filed?
You have to qualify for the homeowner's exemption. You don't have to have it. If you have it, it's easier, right? It saves a lot of steps. If you don't have it, the burden's on you to prove that it was the primary residence, like the original one. And we look things, we can do tax returns, voter registration, insurance, so you have to go through more steps. So it's definitely easier to have a homeowner's exemption, but it doesn't exclude you if you don't have it.
So people are preparing for that as a recommendation, like, they get that before they make their first house.
Because of Prop 19, I recommend anyone who qualifies for a homeowner's exemption have it, no matter what. Because it makes everything you want to do related to Prop 19 so much easier. I do want to add one thing though. There's also this thing called the Disabled Veterans Exemption. So that is available to veterans who are 100% disabled. There's a form for that. You have to file it with our office, but that's also qualifying. So if they don't have and right now you can't have both. So you can't have both a homeowner's exemption and a disabled veterans exemption. So you can have either one of those and it qualifies. And the disabled veterans exemption is substantially larger than the homeowner's exemption. I think, the homeowner's exemption exempts $7,000 of assessed value. I think the disabled vet, I haven't looked it up, it's somewhere in the range of $150,000 exemption. There's also a low income disabled veterans exemption, and it's even more. Okay. So disabled veterans exemption, it's a one-time filing. It's very similar to the homeowner's exemption. You file one time, you provide your documentation. It does require the documentation, and then that is in place. If you have the low-income one, you do have to file every year because we have to verify that you continue to meet the low-income requirements. And an interesting thing is people who have maybe served in the military many, many years ago, and are just now having problems associated with it, so they can. They didn't leave the military service with a 100% exemption, but now they have it. They should contact their office and get that. Okay. Yes.
And then their father inherited, and they raised their kids, and then now one of their kids living over there and raising their kids, and they still pay grandmother's tax, like less than $1,000. I cannot understand that.
They haven't reported it. They haven't reported the deaths.
What's their name?
So that gets me to this one, a couple things. This is a slide I clipped over. We want to go back to this. One common misconception is that if the property is in a trust, the trust is the owner. In property tax purposes, there's lots of reasons you do a trust, right? It's to avoid probate, maybe income tax relation, and there's some property tax reasons. But when someone dies, even if the property is in a trust, the date of the reassessment is that date of death. And it happens all the time. They don't report any change of ownership until they sell the property. 10 years later.
They don't sell it. They keep it in the family. They don't do any repairs or look for anything. But the grandparent, but it's under the father's name, like one of the first owner's kids under the name. But their kids are still living there, plus
babies.
Yeah. I could tell you that in the Los Angeles County Assessor, in one of their major fires, they're having huge problems with that because it's generational, right?
Yes.
And it's 2 or 3 generations now, and they think it's all in the family. Why should we tell the government that we own it now, right? Unfortunately, they're trying to do a workaround, but if those properties burn down, the children
They're not doing anything.
they're not going to get the benefit of the calamity exclusion that only applies to the owner of the property at the time of the fire. And if that person is deceased, then so it's a problem. Another thing is, again, we get this all the time. The assessor's office is not notified of the death until they sell the property. 4 years, 8 years, 10 years later. When that happens, we're required, if the assessor's office is not notified, we're required to issue 8 years of back taxes. And that's going to go to the estate.
I'm worried about like 100 years back.
Well, that is true. It doesn't even, 100 years, because Prop 13 only started in 1928. So, but it can be substantial, right? Because if they're paying $100,000, that's worth $1.5 million. Well, whatever. Okay, say it's worth $1 million. That's 900,000. That's maybe my math right, $90,000 in taxes a year times 8. If they have to, that's right. So it's a problem, and we're working on our outreach on that. We're relying on you guys to help with outreach on that mortgage, anyway. And we're
How far back can you go?
8 years. 8 years for unreported, unless it's a legal entity. Okay? So another way people get around this is they put it in an LLC, which can do some things, but you have to be very, very careful. And if you don't report a change in control of the LLC, there is no time limit. We just went back to 2008. We issued tax bills back to 2008 on a property that had a really low base year value and got assessed at $4 million.
And then what happens? Like, let's say they've been fined for the past 8 years for not reporting grandma's death, and their grandbabies, if they were renting out and getting money. But what happens? Does it go to probate? Because like, is there going to be like tax lien, IRS, like how that goes further down?
I can't say without more information about that type of properties, which you want to do, but you can maybe talk to a tax attorney or an estate attorney to find out more. Okay. So let me just finish this one before we get back. So qualifications, again, this is for the parent-child. It has to have been the parent's primary residence. I think we've established that. Becomes the child's primary residence within 1 year. And they have to file the homeowner's exemption. The way this was originally written, if they didn't file that homeowner's exemption within 1 year, it was also gone forever. So now they've loosened it up a little bit. You can file the homeowner's exemption at a later point. But moving in with that right now, that 1 year is absolute. And yes.
So do they negotiate as far as if that happened, like what you were talking about? Would they negotiate the amount of taxes, or is there no negotiation? Wow.
Well, we established the assessed values, what the market value is at a certain point in time, whatever the date would be. There can be discussions about what that market value should be.
Oh, okay.
All right. And there's informal discussions with my office. And if we can't come to an agreement, everyone always has the right to take it to an assessment appeal.
Yeah.
Subject to forms and filing deadlines. All right. So filing deadlines also apply for there as well.
Yeah, well, to me, it's not like intentional, like what she's talking about. It's just they didn't know. So they know. Yes. Like they I get it.
It doesn't, and it's not me. I just I don't have my office. We don't have the authority to do that.
Yeah.
Right? Because I agree. It's just not nice. They didn't know.
No, there should be. I guess that's what the attorneys are for. So if you know that, but
Sometimes the attorneys. I would make sure you're using an experienced attorney Variance in real estate law.
Yeah.
Sometimes they don't always know.
Yeah.
If you're
When you say, let the county know about a death, is that with both parents die or just one parent? Any.
anyone who owns real property.
So you're called on title.
And if it's spousal, we just update the ownership and nothing really happens. Right?
So it doesn't get reassessed at that time.
Not if it's just spousal. Right? That's the one easy peasy, nothing happens. I love spousal.
So you guys don't get notifications automatically when we drop dead?
So, right, like, it's close your money. No,
So, because I am the assessor recorder, I do have information in the recorder's office from deaths that occur in my county. Right, so like we get a list of that, and that is on our list of things to do to start working through that, so that we can be proactive in reaching out to those people and say, hey, you're supposed to do this. You know, there's benefits that might expire if you don't reach out to us.
Yes.
But it's only if that person dies within this county.
So we should leave the county before we decide.
Closer. This if the person passed away in this county, and did they go need listed here?
So for any properties that a child inherits from their parents, that was rental properties, they're all gonna get revalued.
Yes.
That is so forcing people not to be able to afford to hold on to rental income.
Yes.
I think it's evil.
Yes, and they so they sell, right?
Yeah.
And well, you guys want to buy and sell the houses, right? And there's the properties. So, just some background of how that came about. There was I sorry I didn't read this before I came today. It's about 12 years old. There's some big actors like in Southern California, and they inherited their parents, mansion in Beverly Hills or something, and it was worth X millions of dollars. And I think they were renting it out to like $20,000 a month. And it's like, why is this fair, right? So, I can say, so there has been every year, petition gathering to undo that portion of it, right? To undo the parent-child restrictions, for a lot of reasons. They could never get enough signatures to get on the ballot. No one gets why. Because you're reaching out to voters, not homeowners.
Yeah.
Right? So the voters are thinking, why should all these people get a benefit? I can't even afford to buy a house here. Right?
But it's also been misrepresented when it was going for vote.
Yeah.
What was being stated was so wrong and so incorrect.
I absolutely agree.
And
that this part of that Prop
That's
19
2001.
is 2001.
Yeah.
And they did not really touch on this.
Yeah.
Maybe even in the voter guide, right?
So that's
Okay.
that's about the whole thing.
Go ahead.
I think that's decent.
Actually, that's if you have two parents and they are, let's see, they have the primary residence and then they sell it or gift it to a child, but only one parent applies, then for the exemption, then when the parents move to a different house, can the other parent then no one
Because again, this is where the two different sections differ. So on the base year value, it's only one parent or one person, one spouse.
Yeah.
But on a parent-child, if both parents are on title, both parents are giving it to their child.
Okay, but what if the parents are separated and they have separate properties? So then one parent could give their property base value this way to one child, and then the other parent could also give the separate property base value to child.
So my first question is, you're going to get separated parents to agree to do something like that? but assuming you do.
They have two primary residents.
Yeah, you can't. They have to establish. So if they have one primary residence and they get divorced, one person gets to take the benefit. So they can go to court and argue with that too. So, if they're legally separated, I don't know, that would be a good one to put forth to the PA. If they're legally separated and they both have their own primary residence, could that happen? That would be a question that you would have to submit. Alright, any other questions?
How about rental property? If you move into your rental property, can you now call that primary and then transfer it forward to a new purchase? Yes.
Yeah. So if you have a rental house and you move into that house, yes, it becomes your primary residence, and then you can transfer it. And then one question I get all the time is how long do you have to live there to make it your primary residence? There is no definition for Prop 19. There is no definition. But if you tell me that you're moving into that property to make it your primary residence, so you can sell it and take your transfer base, then that's not your primary residence.
You have to find.
I think for the tax basis, you have to live in it for long as to the rental to get your taxation.
Correct.
But not the 19.
But you still have to.
I think you're going.
That's what she said.
About the age qualifications, 55 at the time of the purchase of the second home or the sale of the
The
first
sale.
sale.
Back to the other question, you'd have to have the homeowner's exemption filed, right?
The property has to be eligible for it. Okay, that is a distinction. You don't have to have it. You have to be eligible for it. But it's a lot harder to prove in retrospect because now you don't qualify until you bought and sold. It's harder to prove in the past that you had lived at that was your primary residence. So homeowners exemptions are always good to have. Yes.
So Justin, loophole on his, what he said, 53,
Yeah.
buy the new house, sell the old house at 55, bring over the taxes.
Yes.
Okay.
Yeah.
I heard back to trust you stated earlier that the taxes are due at the time of death. Right?
Yes, not upon the distribution.
Sell services.
The ownership change is not when it's distributed. It's when the death occurs.
Okay, so we list the property, a trust sells it. And so the buyers get supplemental tax bills within 2 years, year and a half to 2 years. But our sellers are also getting those tax bills from the date of death of the trust.
Yes.
And that I've even seen where you've taken it, it's sold by the trust and put it in one of the heirs' names. How can you do that? They weren't even the ones selling it.
Because we look to the beneficial owners of the trust. We look through the trust to whoever the beneficial owners.
So it takes so long for those to happen. Our heirs have distributed their funds. Is there any way to speed that up? Or any way for us to have a calculation so that we can alert our sellers of what's coming so they can be prepared?
Speaking it up, Prop 19 killed us. I mean, we were swamped. And so we've added new staff, but 2 of them just started last year. Okay? And it takes a while for them to get up to speed. So we are madly working through the backlog. We had a severe backlog, no doubt. We are working through that backlog. In an ideal world, the assessor's office work cycle will be that by June 30th, we'll say 2025, we would have completed anything that occurred in 2024. Okay. That's an idea, and that's still a year and a half, if you're going back to January 24. But that's ideally where we should be, and where we're trying to get back to. Right now, actually today is the deadline, where we still had 2021 transfers. So we worked all the 2021 transfers that we could work. And again, it's the ones that we know of. So if we don't know of it until they sell the property, there's no way for us to be proactive about that. And they're probably, both the buyer and the seller are always getting tax bills at the same time. Because it's based on when you're notified of it.
What's an escape tax?
Yeah. Okay. So, does everyone know what a supplemental tax? Supplemental tax is what adjusts the assessed value from the prior owner's value to the new owner's value, prorated for the portion of the year that it affects, right? Because it only affects part of the year. An escape is sort of the same thing, but for an entire tax year. So if we're working a 2021 event, a 2021 date of death, there's going to be a 2021 supplemental, and then escape bills for 2023, 24, 22, 23, and 24. So 3 years worth of escapes. Interesting fact, good to know. Escape tax bills, if your client contacts the taxpayer, the tax collector's office, before those bills are due, they can get a payment plan. It's the only type of tax bill you can get a payment plan on. Okay, but they have to contact them before it becomes due. But
So it's just the first couple of years of the new assessed value, is that what you're saying?
escape assessments?
Yeah.
Yeah. It's whatever it would have been had we worked it back in 2021. So there's no penalties. It's just what it would have been if we'd worked it timely. They would have had those huge tax bills already every year. Now they're getting hit 3 years at once plus the supplemental. So we are working really, really hard to get caught up. But
A silly question, nothing to do with the problem. If a person sells their $2 million house to someone, maybe their child, for $1 million, you're supposed to be taxing it based on the value it sold at?
No.
Okay, that's my question. You definitely
Very good question.
always
Very good
going back
question.
and reevaluating resales.
Yeah, so the value that the assessor's office is supposed to enroll is the market value of the property at that transaction. If it was listed on the open market, on an MLS, for sufficient length of time for people to determine, should I buy this, should I not, multiple bids, whatever, or price reductions because it was overpriced, that we typically say is an open market transaction that represents the market value. Okay, but if it's between family members or is listed on the MLS for comp purposes only, all of those things, we're going to look at it, we're going to do an analysis. Okay, we're going to enroll a value. We don't always have all the information, so maybe our value is wrong, which is why it's really important the taxpayers read those notices. What we find is many taxpayers don't notice until they get the bill, right? And by the time they get the bill, some of their rights have already expired. So they really need to pay attention to those notices that we send out. Okay? Their appeal rights. So for instance, if you get a supplemental, a notice of supplemental assessment, and you don't appeal within the 60 days of that notice, but then you appeal maybe 2 years later, even if you're successful in your appeal, that value is only going to be effective on a go-forward basis. It's not going to go back to that original supplemental. Okay, so the supplemental notices are key. Alright, so anything else on here? There's a claim for this. Claim form for this, right? Sometimes I've gotten so many responses, well, we checked the box on the preliminary change of ownership report saying it was a parent-child transfer. That still doesn't help me. You have to file a form. You have to document that you need the qualifications. Right. Yeah.
I have another math question for you. Is there a percentage to reference when someone sells for $1 million, buys up for $1.5 million, qualifies for the 55 and over, right? To transfer their tax base? Let's say their tax base is at $6,000 a year. Okay, sorry, yeah, they're at $6,000 a year. They sell for $1 million. They're upsizing to $1.5, and you said that a difference of $500,000 gets assessed into their tax base transfer. Is there a formula or percentage we can do the math quickly?
Look at their tax bill. note what's their assessed value.
Same.
So
Easy enough. Whatever.
250.
Okay.
Add the difference in the between the sale and the 500. So now the new tax base is 750 assessed dollars.
So
And then
percent.
1.2%, 1.2%, 1.1.
Okay.
We'll get that. Another thing about this is they're transferring their assessed value, not their taxes. So when you look at a tax bill, there's all these other charges on it, like all the parcel charges, fire charges, mosquito charges. And so in some areas there's special assessments, big ones, right? So if they move to an area where there's a lot of special assessments, they're gonna say, well, wait, based on my assessed value, I brought my taxes over, I should only have this tax amount. It's not the case. You bring it over your assessed value, and all the other charges are added in. Which brings me to something. Did everyone get a form? No? Does anyone have the extra? So I did send it to the email, and so they'll forward it to you. And you may want just the original copy because you can print these out and hand them out. It has a checklist, it has all sorts of things to give out to your clients at that time. One other thing that while we're talking about the parcel taxes, there were a lot of parcel taxes that were approved in November, right? Does anyone follow that? So they're gonna hit the best tax bills in October. There were quite a few school district parcel taxes. I think in Lakeside, I just got the notice. It was a continuation, but it's $690. It's a pretty big parcel tax, right? So seniors, if it was written into the context of the bill, of the measure, they can apply for to not be taxed, not have that parcel tax on their tax bills. The bills go out in October. When do you think they have to apply? October.
July 1st.
June, May and June. Now. All right. So for school districts, the definition of senior is 65. Okay. You don't file with us. You have to actually go to the school district and go on their website and find where it is, because one of them, Santa Cruz Schools, they contract out, so you have to go there, and you have to file that exclusion form with them. So if you do newsletters, you want to share that info, this is really timely information to get out there, to ask them to apply for the exclusion. Usually, once they do it, it's just a one-time thing.
Is there a resource for all those parcel taxes?
I did one. Actually, I did one 2 years ago with all the school districts, and it's all different now, right? So it was a lot of work. So I didn't do it again. So look at where your client. Tell them to look at their tax bills, right? Or if they remember, hopefully they paid attention to the election. But they're parts of tax playing out there. Anything else? Covered a lot. Yes.
I have a question about trust. We have a trust, and the say the trigger is the child, but the beneficiaries are going to be the grandchildren. How is that?
So the question is, So the question is, there's a trust, and there's a child, but the beneficiaries are the grandchildren. The child is still alive. It doesn't qualify.
So the grandchildren.
The grandchildren will have to pay the higher taxes. Yeah.
So you have to have it to the child, not the grandchild.
The only time it can go from a grandparent to a grandchild is if the intervening child is deceased.
You can't just bypass your own child to save taxes. That's what it is.
Is there anything in the parent to child for a child who is disabled and inheriting?
I think it was exception.
They would still have to meet the same requirements to inherit it, whether they're disabled or not.
I mean, for the tax rate not to go up, so that the disabled child who's inheriting the money so they can live off of it, which is why their parents put it together for them, don't pay 10 grand a month in taxes. Is there anything built in?
If it meets the parent-child requirements, the primary residence,
It's not a primary residence, that's rental.
Can you go parent to child to grandchild?
Yeah.
Can you go parent to child or grandchild? How many of you have heard of the step transaction?
What?
The step transaction. So this is something that we have to use and we have to evaluate. I have a whole section of my office that just looks at these and trusts and all other things. And so what it basically says is if the taxpayer does all these little things to avoid tax reappraisal, then we are required to collapse the steps. And we look at what it was before and what it is after, and that's what it is. So if you do it 5 years later, maybe, but if you're doing it sort of at the same time, it's not gonna work. Yeah.
Just curious, what percentage of the tax does the county actually get? You get to build this work because it's the majority of the state, or?
Yeah. Yes. So there's in that QR code, there's a whole section on that. The county general fund gets 13% of property tax dollars. We are one of the lowest rates in the county or in the state, and we serve a greater population than anywhere else. Santa Clara County, so I forget what the percentage of it is, but like 55% of Santa Cruz County is unincorporated, right? And again, don't quote me on that, but it's a big number. So, and we also have to provide the certain benefits to the cities, so health and human services. We serve the entire county. Other things like police, we just do the county. Okay. Santa Clara County has maybe 5% is in the unincorporated area. They get something like 18%. We get 13%. So it creates a lot of disparity. We are a very poor county, just as far as our budget and everything we do. We are very, very poor when you look at the other ones. I look at another county, I won't name them, North Bay. We have about the same parcel size configuration, 100,000 parcels, whatever. I have 24 staff. I have 52. Like, holy cow, what can you do? I mean, yes, I could do amazing things with 52 staff. But it's because they're rich, they get a lot more money. So those rates were set in 1978 with Prop 13. And what they did is they looked at how much you're spending right now. And at that time, we had a very fiscally conservative CAO. And so we weren't spending a lot. And so that stuck in Harry's court. And there's really no, our current county supervisors are really trying to, at least advocate for change, to educate people about this. And I get asked, do you think they can get it changed? For us to get more, someone else has to get less. So for Santa Cruz County, we're a pretty small county. To get, Santa Clara County can give up some of their money? Heck no. Right? They have way more population to say, it's not gonna happen. So it's tough, right? But we make do. The same thing happens in the school districts. I don't know if you know this, but the rates, the per pupil rates that the schools get, it varies by school district, right? I had kids in both San Lorenzo Valley and Scotts Valley School District. Scotts Valley has one of the lowest per pupil funding rates. SLB has one of the highest. If you look at the facilities, go look at their fields at SLB versus Scotts Valley. And again, that was set when Prop 13 passed. And at that time, SLB was maybe a little bit more struggling, and so they determined that school needs more money. And it's been the same ever since. So Prop 13 was beneficial to homeowners, not so great for county governments and schools. Okay, and I forget what the stat is, but if you look it up, the schools at that time when Prop 13 passed lost millions of dollars of funding, just because the tax base wasn't going to keep going up according to the map. Yes.
I just don't know a lot about government or anything, but I don't understand why our revenue that we create in our county just stays in our area because we have X amount of homes and people versus like you just said, Santa Clara has way more homes and way more people and why do we have to share?
Technically, 100% stays in the county.
100 what?
100% of the money will stay in the county.
Okay.
But most of it goes to the schools.
Where?
In the county.
Okay, it's county.
Right. And then there's special districts, like the cities, the county general fund gets 13%, but the cities get some too. So it goes there. So if you look at the state, they say that 100% comes back in the county. They have to keep any of it. They do some dodgy math with school funds, but I don't know much about that.
Okay, so we do like our you're saying 13% of the county general we
goes to the county general fund
of our county.
Yes, of our county.
Okay, and the rest goes where?
Schools in our county, the cities in our county.
Got it. Okay, I thought like I misunderstood. I thought you were saying it.
I thought it was
shared with like different.
What's that?
Doesn't it all go to the state and then the state redisperses?
That's an auditor question. I don't know the mechanics of it. But if you Google it, the state will say it all stays in the county, right? What the mechanics are, I don't know enough.
So, I wanna ask you about, so with the COVID, we made so much sales, right? And new taxes came to the county bank account or whatever savings. And county now collects so much more property tax than before. Where's that money come on? Like, I understand people put that in the city and county and
Oh, I think we're almost, we're gonna be done, but let's just keep the price of everything in there.
So, go, the Santa Cruz County has a really good budget website. So you go to Santa Cruz County, just Google Santa Cruz County budget, and you can drill down through all of those. And again, how much money the real property goal, how much is grown, that's in the report. They have that first slide with QR code. It's in there. Last year, the real property tax total was $61 billion. Okay. So, I don't know, I can't answer that for sure, but it's in the budget.
it's just like, to be honest, since as a realtors, we cost so much money for them to get with our sales, buys and sales. You don't have enough stuff to keep up with the work, and you are like, how much, 3 years behind the work, did you say?
Yeah.
It's just like, so quick with me.
It took me a while first. It took me a while to convince the county budget team that it takes money to make money, and that they need to fund my department to get this money.
Yes.
Right? So
That's what I'm saying.
Yes, it took me a while to convince them of that, because otherwise, every time we have budget cuts, every department got cut the same. And I was the assessor then, so I couldn't make that argument that if you cut it, you're not going to get your money. And it's not only harmful to the county, but it's harmful to the taxpayers, because now we're stuck doing back taxes. No one likes that. So.
Blame it on Doge. Blame it on Doge.
So I'm available if you have other questions, but I think it's pretty much we've met our time.
Yeah, totally. What do you guys think? I learned 8. Yeah, we hit it. All my questions.
Okay.
I learned 8 things in here, so that was awesome. Cool. Anything else?
Thank you.
Okay, thanks guys.
If you have more questions, you can call my office.